Welcome back to America Decides. Now, I'm going to go through a lot of law firm names and some legal machinations, but I promise you we're going to get to the meat of this in a second. Two law firms based here in D.C. are suing to block an executive order signed by none other than President Trump, that's who signs executive orders, that strips their attorneys' security clearances and ends their interactions, all interactions, with the federal government. WilmerHale and Jenner Block are the latest law firms to bring a legal challenge against the Trump administration. A judge temporarily blocked parts of a similar executive order targeting Perkins Coie. That's another law firm, after it introduced its own lawsuit earlier this month. The Trump administration rescinded an order that was targeting Paul Weiss after that law firm pledged to provide $40 million in free legal services to causes the Trump White House supports. In a similar move today, Skadden and Arps, that's another law firm, agreed to complete $100 million in pro bono work for, again, causes the Trump administration favors, this to avoid becoming the sixth law firm targeted by an executive order. Okay, the preliminaries are out of the way. Scott MacFarlane joins me here on the set. Jessica Levinson joins me now from Los Angeles to break all this down. Scott, cut to the chase. What are the implications here?
Let me start off by saying unequivocally, I think Jessica Major and Scott would be a good sounding law firm. A high-powered arsenal you'd want in your camp. So these settlements...
I'll be of counsel.
There you go. These settlements,
paralegal. Be
it $100 million, be it $40 million, are nevertheless, according to critics of the administration and critics of the deals, incentives to go after more law firms, because clearly the administration's been able to mechanize this to the benefit of the administration. They now have law firms in their arsenal. So we'll start with that. The people who have been in part of the firms that are challenging in court, WilmerHale, Jenner and Block, Perkins Coie, say they're fighting this fight not just for themselves, but for the others, so that they dissuade future actions against future firms. But here's the bottom line. This is no longer a Washington, D.C. or a law firm story. If you chill enough law firms from taking on the federal government, if you scare off enough law firms, somebody in America who has trouble with a veteran's benefit, a Social Security check, lost their federal job, has a back pay issue, is not going to be able to find a lawyer to take the case. And that's a problem.
A big-time, experienced, aggressive attorney.
And Jessica can speak to this much better than me, but this is some pretty tricky stuff. Challenging the federal government. You need not just the manpower, but the expertise of a trained lawyer.
Jessica, we'll get to the intricacies of the kind of law firm and the kind of legal practice you need to take on the federal government in a second. But as I read it, there are 3 of the first 10 Bill of Rights amendments implicated. The First Amendment, the Fifth Amendment, and the Sixth Amendment. Am I right about that?
I think that's right, and probably in that order. And I want to emphasize everything that Scott said, exactly right. I mean, when it comes to the moment we are in our country now, where we see that law firms are really the ones taking the cases to push back against an administration that is embracing a view of executive authority that's broader than, in my view, anything we've seen in recent history. Law firms are part of this, the opposition to the Trump administration, part of the question of how much, if at all, any of the branches will push back against the administration. Because right now, it's not Congress pushing back against the executive branch. It is largely judges, but judges can't act alone. Judges only act when a case is brought to them. And so if cases aren't brought to them, then we do have a real question as to whether or not we have essentially folded into the idea that we don't have co-equal branches and that the executive branch can basically do whatever it wants, regardless of what the Constitution says. Now, I've gone a little far afield from your question. Do I see First Amendment questions, Fifth Amendment questions, and Sixth Amendment questions? The answer is yes, and we can talk about all those in detail. But that's what these firms are arguing, and that's why there have been some temporary restraining orders put in place against these executive orders.
Jessica, take the constitutional ball I've handed you. First, Fifth, and Sixth. Go.
So when we're talking about the First Amendment, we're talking about speech, we're talking about association, we're talking about the right to petition the government. When it comes to law firms, obviously, we're talking about the right to associate with not just each attorney, but also with clients. We're talking about the right to advocate for your client's perspective. And we're talking about the right, again, here to petition the government to say, we don't think what you're doing is correct. One thing I want to highlight with respect to the First Amendment here is that law firms are saying this is the worst type of First Amendment discrimination. It's viewpoint discrimination. When I teach the First Amendment, I say if there's one thing we should be most worried about, it's something called content-based restrictions, and in that, viewpoint-based restrictions, because it's the government saying, be quiet because I don't like what you are saying. The other concerns deal, of course, with any due process rights, the fact that these law firms were not provided with notice, an opportunity to be heard, and an opportunity to contest what the administration is trying to accomplish here.
And Scott, this has to be having or creating a kind of mind-bending conversation in the legal circles of Washington, D.C., because some law firms are taking a shortcut. They're like, what do we need to negotiate, and what's the price?
And how are you scaring off your current clients when you're having these conversations? Are you at risk of losing clients just because your name is bandying about, whether you're cutting a deal or not cutting a deal? These are businesses that require access to government buildings, access to government clients, and security clearances. If you take away any of those three, that's a death sentence for a law firm. And other law firms want to stay off the radar. So you have a metastasizing issue here. Let's see if the settlements end the spread or further the spread.
And some of this, Scott, falls into something that you heard a lot the last 2 or 3 years in relationship to a lot of things and grievances against the government in Washington, the deep state, the idea that there's this cabal. Well, if someone is harmed in the D.C. area or anywhere in the country, and the harming agent is the federal government, and they need a powerful lawyer, they may find it harder, maybe impossible, or certainly more difficult to get what they need.
And you can't go it alone. If you're a federal worker and you have a grievance, you lost your job or you lost your pay unfairly, try taking that to court. That is a Herculean undertaking and probably cost prohibitive, so you're not going to do it. Can't find a lawyer, you can't fight the fight. But if we can quickly put that graphic back up of the 5 law firms, it's worth emphasizing for effect the Skadden law firm. The reason they're on the radar, the reason they're on that graphic, Elon Musk put them on blast on Twitter because he's concerned about their efforts to protect those who protected the 2020 election.
The word that comes to mind, retribution. Scott MacFarlane and Jessica Levinson, thank you very much for your time. I appreciate it.